Call to order the Speech Language Pathology and Audiology and Hearing Aid Dispensers Board meeting. Today is Thursday, January 13th, 2022, and the time is 2:03. Before calling roll, however, I'd like to swear in one of our new board members. So if Amy White is ready.
I'm ready.
I'm going to administer the oath of office. I can't see you, of course, so I'm going to ask you to raise your right hand and repeat the following. I state your name.
Amy White.
Do solemnly swear or affirm.
Do solemnly swear or affirm.
That I will support and defend the Constitution of the United States.
That I will support and defend the Constitution of the United States.
And the Constitution of the State of California.
And the Constitution of the State of California.
Against all enemies, foreign and domestic.
Against all enemies, foreign and domestic.
That I will bear true faith and allegiance.
That I will bear true faith and allegiance.
To the Constitution of the United States.
To the Constitution of the United States.
And the Constitution of the State of California.
And the Constitution of the State of California.
That I take this obligation freely.
That I take this obligation freely.
Without any mental reservation or purpose of evasion.
Without any mental reservation or purpose of evasion.
And that I will well and faithfully discharge.
And that I will well and faithfully discharge.
The duties upon which I'm about to enter.
The duties upon which I'm about to enter.
Congratulations. Welcome to the board.
Thank you.
Congratulations.
Thanks.
We do have another new board member, Dr. Tulio Valdez Vargas, who is unfortunately unable to join us this afternoon, so we'll have to do the ceremonial swearing in at a later time. Okay, I'd now like to call roll. So if you would just say aye if you're here or here. Holly Kaiser. Why don't I come back to Holly? Maybe she's having some mic problems. Todd Borges.
Here.
Karen Chang.
Here.
Gilda Dominguez.
Here.
Debbie Snow.
Here.
Amy White.
Here.
And let me circle back to Holly. I believe she is here.
Dr. Raggio, I believe that we have lost her audio connection.
Okay.
I saw her name in the attendees.
Yeah. She's going to have to call in again.
Okay.
She should be back momentarily.
Should we wait, or we do have a quorum without her? But would you like to wait?
I'm going to suggest give her just a second. Oh, she's saying go ahead and go on. Okay. So, presumably when she's back on, Christy, legal counsel, we can just go ahead and take her role at that point. Is that acceptable?
So, I mean, you have a quorum, so you can proceed. As far as acting on any motion, though, you'd have to wait to make sure she had participated and could vote at that point. Otherwise, we couldn't count the vote.
Okay. So maybe before we start our discussion, then do that?
Correct.
Hi, Sharice. This is Paul. Are you saying that Holly can hear us? She just can't talk right now?
I believe so.
Okay.
I'm not sure about the audio, if her computer is able to play any sound and just doesn't have a mic, or if it has neither. But she is trying to call in right now. So.
Just give her another minute.
It's probably the safest. Just give her a minute. But if you'd like, we can always proceed to introducing the agenda item. since we've already done the swearing in.
Yeah, I just,
Okay, I see her. Hold
if
on.
she's calling right this minute, then I'd like to wait.
I think it should.
See your name listed twice in the participant list.
Hmm.
Looks like there's a phone connection.
Holly, can you go ahead and try and unmute yourself?
Hi, did that work?
It did.
Oh, good. Sorry, you guys. Thank you.
Okay, so just continue with our roll call then. Holly, you're here?
Here.
Okay, good. Okay, we do have a quorum, so I'd like to move on to agenda item 2, public comment for items not on the agenda. So we'd like to open the panel for public comment.
This is the moderator. We have opened the panel for public comment. If you would like to make a comment, please type the word comment into the Q&A box, which should have appeared in the lower right-hand corner of your screen. We will be displaying instructions on the screen momentarily. Until then, use the Q&A box in the lower right-hand corner of your screen, type the word comment, and submit it to all participants, and we will take public comments in the order they are received. If available, can we get a slide for the instructions for public comment? Thank you.
Apologies.
All right. Seeing no requests for public comment, would you like to close the option?
Yes, please. Okay, I'd like to move on to, I have it as item number 3, but the primary purpose of our call today, or our meeting today, and it involves the discussion and possible action on filing a public comment regarding U.S. Food and Drug Administration proposed rule on medical devices, ear, nose, and throat devices, establishing over-the-counter hearing aids. And I believe Paul Sanchez is going to lead our discussion.
Thank you, Dr. Raggio. Good afternoon, everyone. For the past 4 years, we've been discussing the topic of over-the-counter hearing aids, and we're at the point now where we've actually seen the proposed regs and want to discuss them further. First off, I'd like to thank Charisse, our staff members, Charisse and Maria, and our legal counsel, Michael, who have been working closely with me on doing the research and just putting all the issues together for us so that we would be prepared to talk about this. And I'd also like to thank our standing in legal counsel, Christy Schledge, who's covering for Michael Knotes and will be assisting us today. First off, the Usda Reauthorization Act of 2017 established a category of over-the-counter hearing aids and requires the FDA to promulgate the applicable regulatory requirements to establish over-the-counter hearing aids and realign other regulations for hearing aids to reflect the new category. The FDA published the proposed regulations for public comment and will eventually publish final regulations, taking the public comments into account. According to the FDA, hearing loss affects an estimated 30 million people in the U.S. and can have a significant impact on communication, social participation, and overall health and quality of life. Despite this high prevalence and the public health impact of hearing loss, only about 1/5 of people who could benefit from hearing aids seek intervention. The FDA identified several barriers that impede the use of hearing aids in hearing impaired individuals, such as the high cost, the stigma of being perceived old or debilitated, and the value itself, the perceived benefit of the hearing aid relative to the price. The FDA is proposing rules to address some of these concerns. Specifically, the FDA proposes to define over-the-counter hearing aids and establish applicable requirements. Amend the existing rules for consistency with a new over-the-counter category. Provide the state and local government laws that restrict or interfere with the servicing, marketing, sale, dispensing, use, consumer support, or distribution of over-the-counter hearing aids as preempted by federal law. It seeks to repeal the conditions for sale applicable for hearing aids, to amend the existing labeling requirements for hearing aids, and to update regulations relating to decisions on applications for exemptions from federal preemption that would become obsolete as a result of changes to the hearing aid requirements. According to the FDA, this action, if finalized, would clearly define prescription hearing aids and not change the classification of existing device types. In creating a regulatory category for over-the-counter hearing aids and amending existing rules, the FDA intends to provide a reasonable assurance of safety and effectiveness for these devices, as well as foster access to and innovation in hearing aid technology, thereby protecting and promoting the public health. Our staff and DCA legal counsel reviewed the proposed regs and believe that the proposed regs do not impede the board's regulation of its licensees or the enforcement of the board's Practice Act in relation to its licensees. Specifically, the proposed regulations do not create an exemption from the Practice Act's requirements for a person identifying as a licensed dispenser in relation to the sale of over-the-counter hearing aids. We also found that the proposed regulations do not exempt a licensed hearing aid dispenser or dispensing audiologist for being subject to the requirements of the Practice Act, even if the licensee undertakes commercial or professional activities in relation to over-the-counter hearing aids. Board staff and legal counsel do note that individuals would not need a board license to sell, dispense, distribute, or provide customer support for over-the-counter hearing aids. We've also identified some concerns for potential inclusion in the board's letter of public comment and have provided comparison charts on labeling and warranty requirements in attachments B and C to help facilitate the discussion. Some of the concerns that we discussed starts with the use of the word dispenser in the regulations. I'm going to ask Sharice Burns, our Assistant Executive Officer, to go over in detail the concerns that we have and the proposed regulations that we have concerns with.
Absolutely. So in attachment A is the Federal Register for these proposed regulations. And I will do my best to reference page numbers also so that people can follow along a little more easily. So in the proposed regulations, Part 801 would define dispenser, and that's on page 58184. And when it defines dispenser here, it says a dispenser is any person is defined in Section 201E of the Federal Food, Drug, and Cosmetic Act engaged in the sale of prescription hearing aids to any member of the consuming public or any employee, agent, salesperson, and or representative of such a person. So the prescription hearing aid requirements are over there in 801, Part 801. And that is using the word dispenser to define it as a person, a licensed person who's going to sell prescription hearing aids. But then the FDA also put in Part 800, which is on the over-the-counter hearing aids. It proposes an 800.30 in subdivision B. And when it's talking about licensed persons, it says a person that represents as a marketer, seller, dispenser, distributor, or customer service representative, or an equivalent description, is not a licensed person solely by making such representations. And in our in our review of that, it's somewhat confusing to consumers to say in one section that a dispenser is a licensed person that sells prescription hearing aids, but then to also talk about dispensers and say that a dispenser is not exactly a licensed person and they can just sell over-the-counter hearing aids. So the use of the word a dispenser there in both sections is it's confusing to the consumer. And while dispensing of those over-the-counter hearing aids may be allowed under the federal law, it doesn't mean we have to use the term dispenser to identify the person that is selling. You could use seller or distributor, as it is in the other parts of this section. And so we think that that confusion and that use of the word dispenser, which is in the prescription hearing aid and a licensed person, and connotes a higher level of knowledge and skill to assist the consumer. And I think that does create a confusion there. Just slapping OTC in the front of it would make no difference. And then it would also be an issue with enforcing unlicensed practice. Simply using the term dispenser under the federal proposed regs wouldn't allow us to go after unlicensed activity of those over-the-counter hearing aid dispensers just because they left off the OTC part or something like that. So that was the first comment. Is the board may want to go ahead and comment on the use of that dispenser in 800.30 is confusing to consumers, and it should probably be removed because it already defines dispenser in the prescription hearing aid section and talks about it as a licensed person. And sorry, 800.30 of the regs is on page 58177 of the Federal Register.
Sharice, my understanding was that we were going to cover all points and then ask for public board comment. Do you want to
Yes.
do it one by one then?
Yeah, and I was going to hand it back to Paul to kick off the next one, I think it is.
Okay, so we won't be asking the board to discuss this point right now.
Not yet. We'll go ahead and cover our 3 staff points and then kick it off from there.
Sharice, you're gonna cover the next 2 bullet items too, right?
I can.
Okay.
So the next staff issue that was brought up is that the proposed over-the-counter regulations, the ones in Part 800.30, they don't. They provide that state and local government laws that restrict or interfere with the servicing, marketing, sale, dispensing, use, customer service, or distribution of over-the-counter hearing aids are preempted or superseded by federal law. So it would create a preemption of our laws, specifically when it comes to labeling and things like we normally establish a minimum font size so that the poor consumer can read it and doesn't have to bring a magnifying glass into the store to review the product, to read all the information that we've deemed so critical that it needs to be on the outside of a package. It seems only a logical consumer protection to ensure that the consumer is actually able to read it without requiring a magnifying glass. And some of the other things are like the board has recently helped pass AB 435 and the language about locked hearing aids. There's nothing in this labeling requirement that requires notification to the consumer that the over-the-counter hearing aid that they may be purchasing, while let's say it might be programmable, it may actually have proprietary or locked programming software that they won't be able to take anywhere else to get serviced or fixed. And so it because the federal regulations preempt all of these things, we think that it would be really helpful, since most of the over-the-counter hearing aid consumers that the FDA is trying to get these products on the market or out available for are elderly individuals with low income. And in that reason, we feel that there should be an understandable and legible consumer protections with labeling, including, font size, and also letting them know that even if it does say it can be programmed and do all these wonderful things, it may actually not be able to be programmed by anyone. Similarly to the locked hearing aid issue that we have with prescription hearing aids. So that is the second issue that the staff wanted to bring up. The third is they would not modify or otherwise affect the ability of any person to exercise a private right of action under any state or federal product liability law. So essentially, these regulations, and that is in the proposed regulations, it's page 58183, and it's called the private remedies. It's the third column with subdivision 3, so H3. And essentially what that's saying there is that the FDA is not proposing that there be a federal minimum return policy. So in California, the Song-Beverly Act is what requires all hearing aids and assistive devices to have a warranty or an ability to return the product if it doesn't work for the consumer. And in here, it's saying that it doesn't remove the consumer's ability to have private remedies, but those private remedies are often going to be for over the counter that they have to sue someone in order to do something. So if they say, buy an over-the-counter hearing aid from a pop-up store wherever they are, and then the person won't take it back, they won't be able to come to the board because they'll have the protections of Song-Beverly, but nobody to enforce it for them except for the courts. So if you were to buy a prescription hearing aid from a hearing aid dispenser or a dispensing audiologist, the Song-Beverly Act guarantees that you should be able to get a return under specified circumstances, and that's enforced by the board. We enforce that on our licensees, that they have to follow those laws about warranties. Well, the federal regs proposed here would say, oh, well, that state law, if it's general, it can't be about hearing aids specifically, but if it's general, so it's about assistive devices, the civil code sections that apply to assistive devices and the requirement that they be able to be returned within 30 days the law would be in effect, but the board can't enforce that because an over-the-counter hearing aid dispenser could be unlicensed, and then we couldn't enforce that with them. We could enforce it with our own licensees, but not with over-the-counter hearing aid sales only. So if you're not licensed with us, we can't enforce it. And so then many consumers would essentially have bought it. There's a civil remedy, they could sue about it, but they wouldn't really have anywhere to go with that aside from court or the FDA. I'm sorry, so they could complain to the FDA. So that is one of the big concerns there. And I think as a consumer protection measure, the board might want to comment on the fact that a lack of consumer protection exists if there's not a minimum standard for a return policy. And this is especially so since these might end up being very much online sales, and they may be originating from some out-of-state online sellers. So having some sort of federal minimum return policy is kind of a minimal consumer protection that seems very appropriate with over-the-counter hearing aids.
And Sharice, can I add something? This is Paul.
Mm-hmm.
It seems like there's a different standard here too in the way the proposed regs read, where licensees of the board would be held to one standard for the sale of over-the-counter hearing aids, and an unlicensed person would be held to a lesser different standard.
A hard to enforce standard.
Right, and confusion for consumers. I'll go ahead and conclude the parts of the memo that we've addressed. The board staff also recommends that the board may want to discuss output limits, electroacoustic performance limits, and design requirements or lack thereof for over-the-counter hearing aids, and whether these provide adequate consumer protection or merit comments to improve consumer protections for the over-the-counter hearing aids. The staff believes that some of these areas in the proposed regulations can have a negative impact on our consumers, and that the board may want to express concerns via public comment to the FDA. So at this point, Dr. Rajo, if you want to lead the board discussion on any comments they might have.
Yes, I would like to open up the discussion to the board members about not only the points that were made by Paul and Sharice, but any other issues that you've come across in looking at this information. I would just note that it appears while the FDA law did require that OTCs be put into a category of their own, it's not clear what they meant by category, because the new regulations about the proposed regulations that we're talking about today does not put OTCs into their own category with their own rules, regulations, and so on, but rather than put them into simply a class 1 air conduction hearing aid. And there may be some issues that are going to arise because of that. Anyway, I would like to open it up to the board for any discussion, any comments you'd like to make. Maybe you could raise your hand and I'll call on you. Todd?
Thank you, Marcia. For the first point that Sharice brought up as identifying them as dispensers, clearly I would have big issue with that. It's far too easy for the person, the public, to be confused if they say they're dispensing, to then make that leap that they are a licensed dispenser. And I don't see any reason why they can't be just referred to as seller. So I have a real problem with that.
Yeah, I agree.
Dr. Rajo, could I add a comment to that?
Of course.
Yeah, just as the executive officer of the board, and knowing all that we go through to establish the standards and requirements for audiologists, dispensing audiologists, and hearing aid dispensers, all that goes into the development of an exam, only for a consumer to see the word dispenser and make that assumption that this person meets that state standard, I agree 1,000%. It's detrimental to consumers. So thank you for that, Todd.
I have some other issues, but I'll hold off until we get comment from others.
Okay, Amy?
I would just echo support for Todd and Paul and those comments thus far. The use of the word dispenser is utterly confusing, especially given that many of our state licensing boards use such terminology, to refer to their licensees. It's not just California, and it's pretty well established across the country, and that just seems an undue, possibility for confusion from everybody.
Would anybody else like to comment on that particular aspect of our potential letter? The use of the word dispenser. Anybody disagree that there's a problem with it? Okay, I'm not seeing it anymore. Any other hands up? The second issue that was talked about was the fact that the labeling may be somewhat unclear. Not only is it difficult to read small font and so on, but we want to look at the fact that we just wrote and helped pass legislation, AB 435, that says that in California, hearing aids cannot be locked without the consumer being aware of that, having to sign a disclosure statement that says, I understand that this is locked and I may be limited as to where I can get programming services and so on, which successfully passed. So I, for one, believe that we should include not only a dissension about that issue, but that we ought to mention our AB 435 also in our letter. Any other thoughts about that? Amy?
Sure. Well, I was reading, when I was reading that section, which I think is on page 58158, the middle column, second paragraph, defining tools, tests, or software. I'm interested to see what everyone else's interpretation of that is. It does state, the hearing aids, it requires that users be able to control or customize the devices through tools, tests, or software, We interpret this requirement to refer to the ability for a layperson to perform such activities. And on and on. Hearing aids are those devices that allow lay users to control the device and to customize it, such as the device's output to meet their individual needs. So is the thought that perhaps there will be software, where other features are adjustable and that the OTC hearing aid need only to have a volume control, so the user could just adjust the volume and they cannot then customize other aspects of the programming of that hearing aid? And that is the concern. Is that the thought there?
Well, I can't speak for them in terms of what they were intending, but we already know that there are hearing aids out there that are self-programming.
Sure. I suppose I was asking more from the, the points that were raised, by the staff about should we comment on that? Are we interpreting that statement to mean that they can still have locked software even though they're allowing the user to adjust a part of it, like volume control, and that's why we need to make a statement, about making sure that the software isn't locked?
I wouldn't think that's because I think there's very few who actually could do that at this point, but you never know. But I don't think that was the intent. But Paul and Charisse could speak to that if they'd like to.
I think our biggest concern is that we could see this market begin to morph quite a bit. Offering a variety of things connecting to your phone. I mean, some of the things that some of the really nice prescription hearing aids do as well, they coordinate with your phone, they work over Bluetooth, you can program them in different ways. And this will say that it has to be, self-customizable, but what does that actually mean? And does it actually mean they will be able to do that? Or will there be times where they need to take it to their, I hate to use any certain name, but your Bose distributor, or, it's an i item, so you're going to take it to the Apple store, or, those kind of things where you can't just go in and actually program it yourself without a whole bunch of specialized knowledge. So then you would be buying something that's actually kind of not so customizable for the average person. I think that's where my concern was going.
Yeah. And so then, maybe it's they are saying that it needs to be customizable or at least adjustable by the lay person, but they aren't clarifying that, all features must be, accessible by someone, by anyone really to program. But I guess we couldn't require that of the lay person in that case. So it'd maybe be adding a completely different statement about software available online for anyone to help access and program or something of that nature.
Yeah. I mean, and in the whole idea of it that, over the counter, shouldn't they have open access? Maybe, but at the minimum, the consumer should know they may end up buying a product that they can't just get fixed or the software reprogrammed somewhere, even if it says it can do all these things, it might actually be limited to just a few of them.
Yeah, agreed.
I'm just thinking about, over-the-counter glasses. Certainly there's very little a consumer can do other than throw them away and buy another dollar, version that might work better for them, but there's nothing more they can do about it, or anybody else for that matter. Todd, you have your hand up?
Actually, speaking to that, one of the things that they discuss on 58163, they talk about, the different areas that these OTC devices should, at a minimum standard, electroacoustic performance and other things. And it states that, the hearing aid should have sufficiently low distortion, would not introduce excessive noise generation, self-generated noise, and they go on a little bit. An OTC hearing aid would have to achieve these after customization to the individual's hearing needs without the intervention of a licensed professional. Okay, so what customization? Is that customization by the consumer? Is that customization by an 800 number that they're supposed to call? Having that understanding that they're going to have to do this on their own, and they can't come to a professional to adjust this for them. clearly there's some type of customization that they anticipate essentially happening. So what does that look like? And I feel like that should be on the packaging somewhere. I mean, of course, at this point, the package is going to be, the size of an Amazon box with all the things to put on it. But, I feel like there needs to be some type of, labeling that says you're on your own, so that they understand that. They can't buy it and then bring it to me and say, hey, can you fix this for me? Because it will be locked. We know that for certain.
Yeah, so I believe that we will be addressing that. That's a good point, Todd and Amy. We'll be looking at adding language that speaks to those particular issues, because they don't stipulate that, as they don't stipulate a lot of things. And not making it a category of its own, it closes the door to some of those things that should be open if we're going to look at these as a separate product entity. Are there any other comments having to do with labeling or the issue that we've been talking about? Holly?
Hi. Just make sure I'm understanding the conversation. So I'm thinking that when people buy computers, or let's say in speech and language pathology world, they buy an augmentative voice output device. Yes, all of that's programmable, but just as in computers, we often need to hire professional IT people to help us with programming. I would think that is going to be true with hearing aids as well. So are you saying that it's more of a buyer beware, that they need to understand, even though something may claim to be programmable, that they may need professional assistance to do that properly? Is that what you're saying?
And that programming might have to be done in restricted locations. So what if you have to take it back to the same person because they don't share how to program that software widely? So they have to go right back to the Walgreens they got it from, and only Walgreens has some customer support person on the phone they can call and get help with it or something.
We anticipate that licensees, the current dispensing licensees, will in fact be dispensing over-the-counter hearing aids. Now, whether they will, in doing so, have some ability to program the hearing aids is unclear to me. I don't know if Todd and Amy have a thought about that, or have you been privy to information that says that if you're going to dispense it, you will have access to programmability. Todd?
I have not heard anything personally, but that does go straight back to the whole locked issue, right? If I decide I'm going to sell OTCs over the counter and there's from Panasonic or whoever, and there is some programmability I can do to it, they have to know that they got to come to a Panasonic dealer to get that.
So that means our licensees have to abide by AB 435. And even though the non-licensees don't have to have them sign any sort of waiver acknowledging that it's locked, but the licensees would.
Exactly. That's right. That's where I was kind of going with it.
Amy?
And I also don't have any direct knowledge. I guess my assumption over the years of these discussions, listening to the big companies like the Bose and things like that, was that all adjustments would be facilitated by whatever company produced that device, whether that be via, a website, you log in and you can, connect to your hearing aid and make those adjustments, or an app on the phone to make those adjustments. I think more so that than even having any sort of technician on the other end helping make those adjustments. But it may be that the things aren't necessarily locked, but that there's, a portal of sorts that the user can go to have those adjustments done. And if a licensee, a dispenser, an audiologist wanted to assist with that, maybe just going to that portal rather than having that specific, having it be in that regard, it's not exactly locked. It's just going through the portal for whatever brand you bought. But I don't know how to predict it. I don't think enough information has really been shared, at least from the FDA to us or the industry at large, to have that awareness of how that's going to look.
Yeah, I agree with that we don't have enough information about it. I'm just curious about products like Lively, where you buy an online product, but you can do remote programming. There is a person on the other end who can remotely adjust your hearing aid for you. Is that the model? Or I'm not sure how Eargo actually works. Maybe you two know better in terms of programming those devices. Do either of you know, Amy or Todd?
I can't recall for Eargo, Lively, it is absolutely that. You have to be logged in, as the consumer that purchased the device, you go on your app or you go on the web and you make contact with a support person, a provider of care remotely, and they log into those hearing aids remotely to make those adjustments. And I guess, Marcia, that's my assumption, is that's how these other devices are going to work. But it's a poor assumption to make. I really can't recall how Eargo. I thought Eargo came with preloaded program. You send your hearing test result to Eargo, and they preload 2 or 3 settings into that hearing aid before they mail it out.
Right. That's correct.
Right?
And then if something's wrong, you'd have to send, at least at one time, you'd have to send the device back and have them adjust it for you if it didn't come out right, and then they'd send it back to you again. It used to be fairly
and now
cumbersome.
I know that has changed. They'll connect via Bluetooth to the phone, so they've said that their hearing aids are now Bluetooth, but all that means is their Bluetooth connectivity to your phone so that you can log in and have those adjustments made, is my understanding.
So I think we know what there are many tenets to this issue. It isn't just one thing, and we'll be looking at those sectors of the regulations that Amy and Todd mentioned to see if we want to add additional language, which I'm sure we will, to this issue. But we're a little bit hamstrung by the fact that we don't know everything yet. We don't see this. I have been talking to representation from the 5 major hearing aid manufacturers, and my understanding is that none of them plan to get into this market at this point. Things can always change, but that's the case. So it means that companies like Bose and Eargo and Lively that are not part of the hearing aid manufacturer community that historically are going to be taking over this market. So we're going to have to see what they do with these regulations in terms of what the products will look like, how they're programmable, whether they're locked, and how they address that. But again, our jurisdiction is only under licensees, so there's not much we can do unless we see some violations down the road, because licensees will likely be dispensing these. At least some of them will. So we'll have to see. Any other comments about this particular point, though, Amy?
I was just surmising perhaps a recommendation that on the external portion of the packaging, there ought to be an information about how you would address adjusting this hearing aid. You will have to log into a website. You will have to download an app. You will have to call this number. Something of that nature to maybe make it more clear prior to purchase.
Yes, we could certainly make some sort of recommendation of that sort. Any other comments on that particular topic? Seeing none, the last issue is in some ways the thorniest issue of all, and that is the consumer protection aspect of return policy. We can see that there are going to be some portals for consumers to approach the FDA with problems, repairs, injuries, things like that. That is in the regulation. But the return policy historically has always lain with the state. The state's consumer affairs entities would make those return policies. But we're in a kind of catch-22 here in the sense that we have the Song-Beverly language. It's very strict, but again, we cannot impose those rulings on unlicensed dispensers. So I think we want to say something about in our letter that there definitely has to be a return policy language included in these regulations. Otherwise, consumers are going to be really left out. And the fact that we can't impose Song-Beverly ruling on non-licensees means that the only remedies consumers have, as I believe Paul mentioned before, and Charisse as well, is they have to take it upon themselves to get a private remedy. They have to get an attorney. They have to pay the cost of the attorney. And is that prohibitive by the time they have engaged such a person, paid their fees to fight to get a company to take back an OTC hearing aid? So I'd like to open up. I'd like to hear your comments and thoughts about that particular issue. Holly? And then Todd?
I strongly agree that we want to have this population be as protected as possible. We're already looking at doing this because they're more a vulnerable population that may not have the economic, resources available that others do that can that are buying the more expensive hearing aids available now. So anyway, I just want to put out that I totally agree with you.
Okay, thank you. Todd?
Thank you. I think personally we should state, and the comments that we give to the FDA that under no uncertain terms, return of these devices should be under the purview of each individual state that they're being sold in, and not an overarching federal regulation that might supersede that. And then it's up to each state to deal with it, and then that would protect, our own regulations to protect the consumer.
My understanding, though, is that we're between a rock and a hard place with that we can impose that, but we can't impose it on unlicensed practitioners. So even if it is in the purview of the state, and I'm happy to have Paul and or Charisse speak to this, that it's not in our purview because the FDA says we are to not involve ourselves in a whole list of what would be considered licensed activities in this regard when it comes to OTCs. We cannot really do anything unless it's a licensee who's dispensing an OTC. Then we can do something. Otherwise, we can refer them to the courts. We can refer them to their private attorneys, but there isn't much we can do. So how to address that exactly is the issue.
Hi, this is Paul. I just wanted to emphasize that it is a jurisdictional issue because these are individuals that are not licensed by the board.
And so I'm just going to go ahead and pipe in here, Charisse, and so it's on 58160 of the register. It talks about they're not proposing to require the manufacturers accept returns under the federal regs, but they would not consider a generally applicable state or local requirement to accept the returns. So they're hinting that if you have general sales and warranty requirements, some of which are in Song-Beverly, and they aren't specifically just for hearing aids, they're also for just assistive devices in general, that those might still apply. The problem becomes in the actual proposed reg where it talks about that the way that this would be implemented is through private remedies. And so since they're going to preempt the board and these over-the-counter hearing aid sellers don't need to be licensed, which is why they're trying to reduce barriers so that these can be widely distributed or widely sold. But at the same time, if the only remedy is private and not through a state actor such as the board or the attorney general's office, something that can enforce this requirement that is on the books, which this proposed regulation would allow to stand, which is, inside Song Beverly, there's an assistive device section that requires a 30-day return policy. That's only in California, though. And again, the person would have to take them to court if they didn't follow through with that 30-day, as where currently you would come to the board and say, hey, this hearing aid dispenser or dispensing audiologist is not honoring the return policy. And it would move on from there. So it's kind of two different issues. There's not a federal minimum level, which if you didn't want a federal minimum level, we would just need people to know that each state is different. And maybe it's 30 days here in California, but it's 15 days in Georgia and you bought it online from a Georgia seller. There's always those kind of consistency issues for consumers, if you ask me, when there's not going to be just a federal minimum. But there's also the question of like, well, who's going to enforce it, even if it is a federal minimum? So there's kind of a double whammy there.
Well, I guess part of the question is do you guys even want to have to deal with enforcing it?
I don't think we would be able to, Paul, right?
No, I'm just saying in a perfect world, if they were to say, yeah, we'll let you enforce it if you want to, is that something you even want to get in the middle of?
Well, as we mentioned earlier, it would be a jurisdictional issue. I think what we're saying here is we just want to make sure that we want to comment on the fact that there are consumers that would be vulnerable without the specificity of some type of return policy.
And where to go. I mean, they can go to the FDA, but is that the appropriate place to send them to? Is there some other dispute mechanism that can be used? Those are all difficult questions there.
Can I clarify something? It's my understanding that the California Attorney General's office does have a consumer division. Do you see that there's a portal? Is there a portal there where consumers can go to the Attorney General to complain about anything, any consumer product?
Let me take a look while you're talking.
The other thing I understand is the general feeling is that most manufacturers will be offering a return policy for their products. Now, they can't be made to do that, but it looks as though for goodwill purposes, they are allowing that, as do most consumer products manufacturers. So it may not be a big issue if that's true. But of course, we have to see whether that's really the case. Christy.
So I just wanted to address the question about jurisdiction that your executive officer has raised. Typically, the way we enforce against unlicensed persons is through citation and fine and order of abatement. But since the feds have decided that we're no longer going to be able to enforce that aspect with this new category, that kind of takes it off the table for the board implementation and jurisdictional wise. And so it would be, I have never seen the federal law allow us to implement a piece of law which is clearly intended to supersede all of our licensure statutes with respect to this issue, to allow over-the-counter sales without any kind of licensure oversight, except through their rule. So it would then default to, local law enforcement to enforce Attorney General's office, U.S. Attorney, perhaps the FDA here in this case too. So that's what I think executive officer is referring to. Is that correct?
Yes, that's correct. Thank you.
Does FDA have representation in each state? Would you know? Anybody?
I believe they do. I know that they have a list of contacts for every state on their contact. They call them consumer complaint coordinators. I'm not sure exactly how it works, but I know that when you try to contact the FDA and you want to file a complaint, they have a list of every state and the complaint coordinator contact information. It's a phone number.
Well, they may develop something via those mechanisms, although we need to comment about it and stringently make the point that this is a serious consumer protection issue.
And for the board's clarification, I did find on the Attorney General of California's website, if you click through enough pages, you'll find the consumer complaint against a business/company. After you get through, I think it's complaints about refund policies. It's the very bottom online complaint form there. So there could be a general complaint there. Does ask you for all the information, whether there's a court pending action, and so on.
Well,
so as the board, we could link people to this as well on our website when we talk about if and when these come out, where do you go? Where can you go?
Yes, one possibility is listing a number of avenues of recourse for consumers on our webpage ultimately. Yeah. Any other comments about return policy issues from the board? Gilda?
Yes, and can you hear me okay?
It's not very loud.
No? I'll get really close. I just wanted to make a comment. It's really important to protect the consumers and make sure they're not exploited by these companies that are selling these items and not making it difficult to get a hold of someone when the item is not working effectively for them. So I think that is another point to consider. This 800 number, is it someone who is accessible to the consumer, or whether it is mailed? How long is that time frame between it being mailed in and to them, whether they get a replacement or it's repaired, for example? So I think those are other points to consider to make sure that we are protecting that consumer from having exploited.
Yes, I agree with you. And I think we will be developing some language that addresses that specifically. Thank you, Gilda. Any other comments about this particular issue? Seeing none, I'd like to address probably one of the more difficult elements of these regulations, and that is that the regulations do stipulate output limitations on these hearing aids, but over-the-counter hearing aids, but it doesn't list any kind of gain requirements, and as well as other things beyond output limitations. And that, I think, has the potential for being people being underfit, overfit, inappropriately fit, in danger of noise-induced hearing loss. There's a lot of consumer concern about that without being as prescriptive as they can be, without being prescriptive. And I'd like to open up to, I don't suppose other board members can address this besides Todd and Amy, but what do you think about trying to ask for more definitive electroacoustic elements to these products?
Well, I was digging into that quite a bit on those in that section. I found it interesting, the discussion as to why they're proposing not to limit device gain, because they believe that proposing the maximum output limit will provide reasonable assurance of safety and effectiveness. They cite, NIOSH and their gauges of what's acceptable for 30 seconds of exposure, and the thought being, well, if the hearing aid is louder than what is really appropriate for the patient or the consumer, that they would then, remove that device within 30 seconds and therefore not have extended amounts of noise exposure, and that because of the way people react to loud sound, that we're gonna help ourselves out by taking them out appropriately. I think that's a fairly large jump. I mean, it's a big assumption to make that people won't continue to listen to something that is loud enough to damage their hearing and be aware of that. But on the flip side, we've got output limits on pocket talkers of 124 dB, 120 dB, and those are freely available without prescription as well. So I do have concerns, but then balancing that with what is already out there on the market, and I see the argument, I see the justifications that they're making, and I don't know. It's a hard one, Marcia.
No, I agree with you that it's just because they're out there, though, doesn't mean that's a good thing, and that needs to be addressed on its own, at least by the national organization, if nobody else. But the notion that an elderly individual is going to know when to take a hearing aid out when things are too noisy or leave the room, and those kinds of things are huge assumptions that if it were true that people could protect themselves from noise-induced hearing loss, we wouldn't have the massive problem we have in this industrial country.
Exactly.
Noise-induced hearing loss. They're not going to walk away from that. So I think that's an assumption that's faulty to begin with. Also, I think some of their assurances of safety are based on PSAPs, which are not meant to be devices for people with hearing loss. So I think we have to address the potential problems here with damage to hearing. Todd?
Well, clearly, if people were smart enough to take the things out of the ears when it was too loud, then there wouldn't be a teenager alive now that didn't have earbuds in his ears that wasn't going to need hearing aids when they're 36.
Yeah, true.
So, I mean, they're addressing just, as you said, output limiting. And I mean, the fact that, they're going to reduce it to 115 dB if they don't have like wide dynamic range compression. Okay. I mean, that's, yes, from an instantaneous loud sound, yeah, that's great. But the long-term effects of having it set too loud that they're not necessarily going to notice, is a concern for sure.
With no gain limitations, you could take average speech and pump it up to levels that you could only be in for an hour to 2 hours without causing damage. And I don't think people are going to wait it's for an hour or 2 hours.
But there's no way for them to know that in these devices, right? Because they don't know what the person's hearing loss is, so they don't really necessarily know what they actually need. The person's going to set it at a level that they find is comfortable for themselves and theoretically leave it there if they're adjusting it through an app on their phone or through the computer, something like that. How would they set a gain limiter? And how would that be set? Because there's nothing, these things are kind of set right now through the programming because we know what their hearing loss is.
Well, I think the implication is that we should have something like a gain range rather than a limiting on gain, and you would buy the appropriate product. But of course, we're asking people to know their own hearing loss. I think the studies show that the correlation between perceived hearing loss and audiogram is very poor. People cannot dictate or determine their own degree of hearing loss with any accuracy. So trying to pick a product that is meant for this or that degree of hearing loss or this or that amount of gain need is probably a pie in the sky notion anyway.
Well, and I think that's exactly why they don't address the issue of gain limiting because of that. They're focusing on output limiting because they want to protect their hearing from, those sudden loud sounds. But how do we do that since they don't know what their hearing loss is? And the person's not going to know. It's not like when I go buy my reading glasses, I can, look in the little thing through the magnifier and find the one that looks comfortable and pick it off the shelf. They're probably not going to have something like that for these OTC devices. So that is kind of a tough thing to administer, something like that. I agree with you, but I don't know. I think that's impossible for them to regulate.
It may be, but I think it's still valuable for us to put in our letters our concern, our letter, a concern about having the lack of these kinds of stipulations, or at least range values that would at least ostensibly protect people's hearing. But you're right, it's a thorny, difficult issue, and that's why they didn't address it. I agree with you there. And the other issue is, it says for perceived mild to moderate hearing loss. Even people who publish research that supports categorization of hearing loss, there's no agreement among them of what the upper limits of moderate is. Not that these people are going to go look up whether they think they meet this or that requirement unless they have a hearing test. So I think a part of what we should be saying is that people should seek hearing testing by a professional, whether they buy a hearing aid from them or they don't, or they go to an OTC. They should professionally be evaluated to look at what their degree of hearing loss is. So if it happens to be in the severe range or no hearing loss at all, or hidden hearing loss, that they're not spending their money on this on these products unnecessarily. Cherise?
Isn't that one of their labels? I'm sorry.
I'm sorry. What is the label?
Wasn't that one of the labels where they say you should seek a professional to get your hearing tested?
Well, I think we should say they should have them tested.
Yeah.
Yes, professionally, something like that. Because, they have to say it the right way.
Yeah, I think they say you can seek assistance from a hearing healthcare professional. I was just going to kind of chime in as a non-professional here, but that has family members that have had hearing loss. And, I could see where if these were on the market, they might go out and say, oh, well, I have a hard time hearing in some of these circumstances, so I'm just going to go buy it and then I turn it up. But, they actually have a specific range of hearing loss, and this is going to betray my lack of understanding here, but I know it's different tones for my family member. And so that person needs an actual prescription hearing aid device set up for them. But if there was an over-the-counter thing that was relatively cheap, that might have been their first route to go. I'm not going to go get my hearing tested. I'm not going to go to an appointment or get a professional. I'm just going to go ahead and try this thing. It's a couple $100. And then, of course, with their hearing loss, have it way up high just so they can hear a little better, but also cause themselves potentially harm. So I think if there's any sort of, if it's a range or if it's even there's a maximum level, and that's a good maximum level to put in there for the gain or the output or both, or some mix of the two, that's something worth identifying there. Just from the consumer perspective.
Yeah, I think we should use some language. If it isn't specific, at least bring up the issue that the potential is there for consumer harm if they don't address it beyond what this kind of weak level that they've done now.
I mean, it is quite a conundrum, right? Because if you don't allow enough gain, then the person with the moderate loss isn't going to perceive any benefit because they can't turn it up enough. But if you allow too much gain, then the person with a mild hearing loss could potentially, or no hearing loss, could potentially be damaging their pretty decent hearing. And so because it's supposed to fit this wide range, from normal to moderate, how do you suggest making it safe, or how do we decide what that level is while still allowing the device to have some effectiveness for those individuals? And short of a big warning on the box, like this could potentially damage your hearing if you have normal hearing, please don't use this. I don't know how we would decide what an adequate level would be. Is that 110? Is that 105? It's hard to say.
I think the notion is to put a range in for gain rather than an absolute output level that would serve the moderate hearing loss, but not allow it to be loud enough to cause damage. I mean, the packaging will say perceived mild to moderate hearing loss. It's up to you to, judge whether you fall in that or not. A long time ago, if you might recall that when Costco started dispensing hearing aids, there was a lot of consternation about that. And many people thought that, well, that's the place they'll go to get their first hearing aid because it's cheaper and they're not really sure what they're looking for and so on. So that's okay. Their second hearing aid, then they'll go to a professional. And there's some notion that I don't know if that ever turned out to be true or not. But I see a lot of folks who come to see me with online hearing aid purchases that they find unsatisfactory. Not necessarily Costco, but online products. And I'm wondering if that might be the case, that this is a first hearing aid kind of thing. And it will turn out that people will seek professional care later. I'm just speculating. It doesn't affect our letter.
It's very frustrating. I mean, because you think, even my iPhone will alert me now if I'm listening to something that it's beyond a safe level, potentially safe level, to at least tell me that I could possibly be harming my hearing if I continue to listen at that volume. And I didn't see anything on the packaging. I saw the warning about if you're under 18. It almost seems a little irresponsible not to have some sort of warning to indicate that there is potential to do harm. If you're unsure about your hearing loss level, you really ought to seek assistance because of the potential for harm.
Yeah, I agree. Some language like that should be in there. Any other comments or thoughts about the return policy? Not return, sorry, about the electroacoustic standards? Okay, not seeing any at this point. I would like to have the board consider a motion, a recommendation for a motion, and I'd like to read a potential motion that the board should consider, and that is that we move to direct the executive officer to prepare a draft letter summarizing the board's comments made at this meeting regarding the FDA's proposed rule on over-the-counter hearing aids for final review, approval, and signature by the board's chair. Upon approval and signature by the board's chair, the executive officer is directed to submit the board's letter and comments regarding the FDA's proposed regulations to the FDA prior to the end of the public comment period, which I believe is coming up on January 18th. So that's the motion language that we need to be thinking about. But before we vote on that, I would like to take public comment on all of the issues that we've talked about. I see Todd has his hand up, though.
Yeah, actually, I had one other thing that I wanted to bring up on page 58166. They're asking for comments on whether prohibition of sales to people younger than 18 without the need to verify age. So essentially, they're saying, should we not put a label on it that says prohibited for under 18?
I thought they were.
Well, that's why I was a little bit unsure, because it says they're wanting comments about whether a prohibition of sales to or for people younger than 18 years without need to verify age would best promote access to the devices while protecting the hearing health. So it's like they're saying, should we or shouldn't we?
So the warning label is on the package, or is proposed to be on the package about not selling or not using if you're under the age of 18. I think this is stating, so when you go to purchase this at the Best Buy checkout counter, do they need to verify from your ID that you're over the age of 18 and you're allowed to then purchase it? And, online, when you're doing that, it may be a pop-up box that just says, what year were you born, or whatever the case may be, to verify that you're over the age of 18. And that's why they go into that whole discussion about, they're worried that would prevent more access because not everyone has an issued identification card and so on and so forth. So they just it looks like they're feeling like they didn't want to require verification of age at the time of purchase.
Well, I think they should verify age at time of purchase. I mean, the warning says if you're younger than 18, don't use this. but it doesn't necessarily say you're not allowed to purchase this if you're under the age of 18. So that's my point. Is this something where we want to actually prohibit someone under the age of 18 being able to just walk in and buy? Or are we okay with that?
Well, I suspect most of these sales, as was mentioned earlier, are probably going to be online. I'm not sure how they verify.
Well, I'm just saying, should we be making a comment to that effect, that we feel it should be prohibited under the age of 18 without seeing a doctor, or if we're just...
I think there's nothing wrong with adding a statement about sorry, just got a message here I don't understand. That we should say something about that we want some sort of verification of age before allowing to purchase. Is everybody agreeing we should have something like that?
I would support that. I don't know how much it'll do for us, but I can completely see Todd's point, and I don't disagree.
Yeah, it wouldn't hurt at all to make that. That's important to us.
I agree with that as well. Yeah, that's whether we can get them to do it or not, we should suggest that.
Okay, so duly noted. Okay, so we do have the motion in front of us, but I would like to ask for public comment at this point. Oh, I'm sorry. Christy, did you want to add something?
Two things. First of all, I would do the first and second on that motion before taking public comment, because then you wouldn't have to take public comment again, because it's when the action is before the board that you have to take it before you vote. Do you see what I'm saying?
Yeah.
And then secondly, just want to clarify the comment on 58183. If you look at sub G at the top, it says the sale of an over-the-counter hearing aid to a person younger than 18 years of age is prohibited. So it is prohibited. You're just saying you also want them to verify that they are 18 or older. Is that correct?
That's what I'm saying, yes.
Okay, I just wanted to clarify that. Thank you.
Okay, I'll come back to what you first said, but Holly has a comment.
No, I do not.
Okay. Okay, it sounds as though Christy would like us to vote, at least preliminarily, on the motion. Would anybody like me to read it again? Or Todd, do you have another comment?
Nope, that's it.
Okay. Would it be helpful for me to read that one more time? To read the motion, and then I'll entertain somebody moving to do that if they agree. Not necessary? Okay, I'm not seeing any comment either way. So I would entertain someone introducing that motion.
I'll motion what you just said. I don't know. I couldn't articulate it as well as you did.
Don't give me any credit. I was reading it. Yes. Okay. Do we have a second?
I second. This is Holly.
Okay. All right. We have first and second. So now we'd like to take public comment on the motion and the discussion.
This is the moderator. We have opened for public comment on the motion. If you would like to make a comment, please type the word comment into the Q&A box, which should have appeared in the lower right-hand corner of your screen, and send your comment to all participants. We will take comments in the order they are received. And now let us take a moment to see if we receive requests for public comment. Seeing no requests for public comment, would you like to close the option?
I guess so. So are there any
Did we
further
did we
discussion?
want to, oh, sorry.
Todd, you want to raise your hand up?
I didn't know if we want to clarify that the public can also raise their hand in case they're having difficulty with the chat feature.
So since the window's still open, should we make that statement that you can raise your hand?
Yeah.
Or I believe you can type into the...
Yeah, either one. We've had people with different technical issues over time.
If you would like to raise your hand or type the word comment into the Q&A box and make a public comment, we will accept comments in the order received. Seeing no request for public comment, would you like to move forward?
Yes, please. Is there any further board discussion on our proposed motion? Seeing none, I would like to ask Charisse to call the vote.
Absolutely. Dr. Raggio,
Aye.
Ms. Kaiser,
Aye.
Mr. Borges,
Aye.
Ms. Chang. Aye. Ms. Dominguez,
Aye.
Ms. Snow,
Aye.
Dr. White.
Aye.
Motion carries.
Would like to thank everybody for their thoughtful comments on this issue. We'll see where this goes. I'm sure there'll be many more elements that we'll be looking at in the future, but thank you for now. I'd like to move on to future agenda items. I'd like to ask the board members if there are any future agenda items they would like to mention at this point. Okay, I'm not seeing any hands that go up from the board members. Can we open it up to public comment on future agenda items they'd like to mention?
We are now open for public comments on future agenda items. If you would like to make a comment, please type the word comment into the Q&A box, which should have appeared in the lower right-hand corner of your screen, or feel free to raise your hand by moving your cursor near your name and clicking on the raise hand button. We will take comments in the order they are received. And now, let us take a moment to see if we have requests for public comment. Seeing no requests for public comment, would you like to move forward?
Yes, please. Okay, our next agenda item is closed session, but we do not have a closed session today. So we won't be discussing anything further with that. Again, I'd like to thank everybody for their time and interest in this topic today, for participating, for your thoughtful comments. And if there's no other comments, I would like to adjourn this meeting.
Thank you, everyone.
Thank you.
Thank you. Bye-bye.
Thank you. Bye, everybody.
Bye.
Welcome on board. Bye-bye.